Hello, my name is Olurotimi Osha. I like talking about American presidents, and I'm continuing my discussion in honor of Black History Month. I did an earlier video talking about uh, the Supreme Court's ruling that the prohibition against interracial cohabiting uh, was unconstitutional in the case of McLaughlin versus Florida of 1964. That set the precedent for the case I want to discuss today, Loving versus Virginia, which most of us are familiar with in America. Of course, Loving versus Virginia, 1967, decided after the McLaughlin case. It is widely noted as the Supreme Court decision that ruled that anti-miscegenation laws and generally prohibiting interracial marriages were unconstitutional, clearly violating the 14th Amendment, equal protection of the laws, and it also ruled that it violated the due process of the laws as well. So I'm going to break this video into two because I'm going to get into the case history. It's a bit long, but what I wanted us to get out of this case is especially for us um, new Americans of African descent. Of course, someone like me, I'm Nigerian American. I'm a naturalized American citizen, and of course, I'm from Nigeria. And there are many of us, who are from Africa who are now naturalized from Africa who are naturalized U.S. citizens. There are also the new um, American citizens born here, but they're not descendants of FBA. That's Foundational Black Americans, African Americans who are descendants of African slaves. So importantly, Black Americans have had to resort, apart from the marching, right? Apart from the civil rights movement and the marching, the nonviolent protests and activism, they've also had to resort to the courts. They've had to, as we saw in Brown versus Board of Education, and it's taken very long periods for them. They've been patient, they've gone to the courts in order to assert their constitutional rights, in order to challenge a bad law, to have it overruled. And this didn't start in the 20th century. This didn't start after slavery. Um, Black Americans had actually used the courts in freedom, what were called freedom suits. I think I'll do videos discussing freedom suits as well during the era of slavery. Because remember, when slavery started, um, from the Compromise of 1820, once slavery was prohibited in the northern states, right? Uh, there was a division, right, between North and South, so that we had 11 free states where slavery was banned, and then we had 11 slave-holding states in the South. So, and it was divided, the 3630 line or parallel, right? So that was so since that time, it meant there was a rule that if a slave, you know, if a slave owner took their their slave outside outside of the slaveholding states and went into a free state, then it was understood that the slave became free and they could file freedom suits at the courts. And this was what was going. It was a practice. Many slaves had won their freedom by filing these freedom suits until the case of Dred Scott. And we know Dred Scott made it all the way to the Supreme Court under Chief Justice Roger Taney, who is from Maryland, the notorious state of Maryland. In 1857, he said that no, that he violated a precedent that, you know, Black Americans had utilized in the past, right? They'd used the courts to file freedom suits, but now Chief Justice Taney was claiming that, well, that Black Americans could not be American, citizens. People of African descent could not be American citizens, and that they could not file, um, they could not file, suits in a court, right? Which was in contradistinction to the precedent, right? Prior instances of freedom suits that former slaves had filed and won. Um, so they also said that blacks did not have any rights that a white man was obliged to respect. So things changed, and so uh, in any event, Black Americans continue to file suit, and we see that's the case in Loving versus Virginia. So I want to remind us that new new citizens, right, of African descent who consider that their rights have been violated, they have to be prepared to go to court and challenge the constitutionality of an action. Of course, I've talked about my instances, but I'm not going to get into that now because I want to discuss the interesting case of Loving versus Virginia, which ruled that, well, anti miscegenation laws prohibiting interracial marriages were unconstitutional, and that's what allowed, of course, the what we see today, the norm today amongst Hollywood and in society generally. That's why the Kardashians, Kim Kardashian, could legally be married to Kanye West and move around freely throughout America, and it wouldn't be considered a crime. So, well, California wasn't a slave state anyway, but again, they'd be restricted from where they move, right, where they move around to. So let me get into the case of Loving versus Virginia. Interestingly, so Richard Loving was a white guy, and they lived in Virginia, counting in Virginia, and Virginia had the Racial Integrity Act of 1924 and other, racial integrity laws, which reinforced anti-miscegenation laws that had first been passed since the 1660s and during the era of slavery. And so these racial integrity laws prohibited interracial marriages or sex between white people and colored people, right? So the southern laws were importantly keeping whites away from trying to keep them pure and keep them away from black people, Native Americans, Asian Americans. So that was the purpose of the racial integrity laws and the anti-miscegenation laws that existed in the Jim Crow South. This was the era of the Jim Crow laws, right? So uh, Richard Loving was a white male, and Mildred, she got pregnant, and so when she got pregnant, what happened was because of those laws, the anti-miscegenation laws, they made it took a trip to D.C. and got married, and so they came back and were living together. The police got wind, and they raided them at night, hoping to be able to catch them having sex, so they could charge them because interracial sex was also prohibited, right, in Virginia. So so they raided them. Mildred shows them the marriage certificate that they were married, and the police officer tells them that, well, that's not valid. Their marriage was not valid in Virginia because of the anti-miscegenation laws that existed. So eventually they were taken to trial, then convicted in the court of a judge, Leon Bazile. They were sentenced to a year imprisonment because it was a felony in interracial marriage. Interracial sex was a felony in Virginia. However, their sentence was suspended on condition that they did not live in, that they left Virginia, right, and did not return for 25 years, right? So their sentence was suspended. So even though they were convicted, that was in 1959, they subsequently moved to DC in order to avoid uh, going to prison. So they lived there for a long time, and until about 1963, um, Mildred uh, Mildred Loving was frustrated, and she wrote the Attorney General, who was Robert F. Kennedy. Robert F. Kennedy was Attorney General. This was in 1963. She wrote him, and stated that expressed her frustration. And so writing your politicians, your is always a good idea. Throughout my case, of course, I've taken my matter to Congress. I've contacted the office of Congressman um, uh, Jamie Raskin and several other uh, people in Congress, right? So that's an aside, but I'm just trying to remind new American citizens not to be afraid, to be on the side of the law, right? We have rights, you have constitutional rights, and you shouldn't be afraid of bad actors. They're people who are rogue agents in the government, right? They're bad actors. There are many people who are racist in the in government, and they abuse their office to intimidate and harass American citizens. And so this is what I've been experiencing. And I really wanted to talk about this case, in order to show how you shouldn't be afraid of anything. If you're breaking the law, that's when you have something to fear. But if you're asserting your constitutional rights, a government officer, government agent who's violating your constitutional rights is actually the one doing something that's criminal, and you shouldn't be afraid to assert your rights. Many times, government agents, they are there's deference given to them that they're acting in good faith, so that and many times they have absolute immunity or qualified immunity, as the case may be, so they might not be prosecuted for their egregious bad actions violating one's citizens constitutional rights. But I don't want uh new American citizens to be scared of exercising their rights or going to the courts and following the legal process. Yes, will some bad government actors attempt to intimidate us? Yes, they will do it sometimes, because I've been experiencing harassment, but I've gone through the process, and I've been following the legal process, and so, but you should do it fearlessly, and so long as you're following the law, just you will find that justice will prevail. And as we see what happened eventually in the case of Loving versus Virginia. Um, so she wrote Attorney General Robert F. Kennedy that she was frustrated in staying away from her family, that her and her husband, when they were away from their family and their friends, they couldn't go back to Virginia because of the law, and that their rights were being violated. So Robert F. Kennedy wrote her back and advised her to contact the ACLU. The ACLU is very important. That's the American Civil Liberties Union. They still work today. They're very active. I wrote them with respect to my case, but they couldn't help me. So they couldn't help me. I wrote a number of different organizations, and I'm seeing how these organizations are very limited. I think the more political the case is, the more it's in the media. That's when they take it on, or when they're trying to make a political statement. But in any event, there was a volunteer attorney, Bernard Cohen, who helped her. Bernard Cohen, became the volunteer attorney, and then he got on board and filed a motion to vacate with the Judge Belize. In the meantime, they filed, with the district court as well, the federal district court of Eastern Virginia, so that the objective was for it to possibly go all the way, to the Supreme Court, right, once it enters the federal process. So it can also go from the once it from the Supreme Court of Virginia. But in any event, um, something that I didn't point out was the race of um, Mildred Loving. It was kind of interesting because movies, folklore, even the cases in law school, they always refer to her as a black woman. And when you see her pictures, because their photos are very popular, The white guy is Richard, that's the husband, and then the female is black, that's Mildred. And of course, the phenotype of Mildred, the phenotype, expresses what we consider black or what black Americans consider black, right? But interestingly, um, it was, you know, the police officers who wrote the incident report, who arrested them in their home, had uh, described her as Indian American, as Indian, right? Native American. While she was supposed to have self-identified as Indian, right? Of Rappahannock, Indian, Native American, right? Not mentioning her, black heritage. Subsequently, in court documents, they said in court that she identified herself as being, mixed with Native American, with Cherokee, Portuguese, and Black, African American, African ancestry, right? Black American. So it's kind of interesting. The reason I bring this up is because she was still alive in 2004, and they said she denied being black in 2004 and said she was not black. But when you see her phenotype, and of course because of the one drop rule in America, which is of course is it's a racist rule, rule of hypodescent. One drop rule, it meant that you have one drop of African blood, you are black in America. That was the hypodescent rule. So that was kind of interesting, uh, you know. But in any event, the case goes to Judge. Uh, it goes to Judge Belize. They filed a motion to vacate. It takes a while. He didn't hear it for almost a year. He didn't decide on it for almost a year, and then it went through the federal system. Eventually, it was denied by Judge Belize, the motion to vacate, and because Bernard Cohn, he cited it being a violation of the 14th Amendment, equal protection of the laws. Um, so, um, you know, equal protection, let me remind us of what the equal protection and due process, the due process part of the clause is that no state shall deprive any person of their life, liberty, or property without due process of the law, nor shall it deny any person within its jurisdiction the equal protection of the laws. So the ACLU was claiming that you know the anti-miscegenation laws violated the 14th Amendment, which of the equal protection clause of the 14th Amendment. However, Judge Belize, Leon Belize, interestingly, he denied it, and in his ruling, he said that he stated something about how the Almighty God, he was citing an 18th century racist in interpretation, right, of the races, of the races of humanity, of mankind. So he said that the Almighty God, you know, created, you know, people, white, uh, white, black, yellow, Malay, red, and separated them, put them all on different continents, and there was no reason, right, to mix. There was no reason for an interference, right, to alter the arrangement, and that it was if God placed these races on different continents, right, then you know there was no reason to try and mix them, right? So there was no reason to try and mix the races. They separated the continents in order to ensure that the races should not be mixed, right? So that was his reasoning. That was his rationale um, for saying that well, the anti-miscegenation laws were proper, So eventually, he went all the way to the Supreme Court, and the Supreme Court they affirmed in parts, remanded in parts. They affirmed in terms of that no, that it's not unconstitutional. That's the race integrity laws, that the anti-miscegenation laws were not unconstitutional because they claimed, they used as precedent the case of Pace versus Alabama of 1883, which I discussed when I did a discussion of McLaughlin versus Florida of 1964. The court said, Virginia Supreme Court said that uh, the precedent in Pace versus Alabama, emphasized that uh, these anti-miscegenation laws were not unconstitutional because the penalties, right, were equally administered to blacks and whites, right? The penalties were the same. So therefore, it was not a violation of the Equal Protection Clause of the 14th Amendment. So that was that. Now, they remanded in part by saying that, well, the sentencing was vague, so they referred it back to the lower court that they should resentence, right? At which point they filed a writ of certiorari. That's the plaintiffs, uh, that's Loving and ACLU filed on their behalf, and then went all the way to the Supreme Court. The Supreme Court decided to hear it. It was December 12th, 1966. They decided to hear it, and the Chief Justice of the Supreme Court at that time was again Earl Warren, who played a very consequential role on the courts from the time of Brown versus Board in 1954. We know he was very prominent in the 60s. Remember, he headed the Warren Commission, um, which is eponymous, named after him, after the JFK assassination. By the time it got to the courts, 1966, 1967, and they made their decision, their ruling, uh, you know, President Lyndon B. Johnson was president at that time. And so what happened was the courts said they found the law unconstitutional. That's the anti miscegenation laws to be unconstitutional. They criticized the narrow use the of of the claim, the justification that, well, because the penalty for violating the laws, the dubious laws, right, were equal, right? Therefore, it wasn't a violation of the Equal Protection Clause. So they said that was that was dubious. That was not a proper. It wasn't a proper justification, for saying that the Equal Protection Clause was not violated. So that was ruled out. And besides, the Pace versus Alabama precedent in the earlier case of 1964, the court had already decided, it was the same court, in 1964, they had said, well, that, they couldn't criminalize, they couldn't, make an action, conduct criminal based on race, solely based on race, that it was suspect. So in this case, the courts decided to apply strict scrutiny since the law implicated race. So they applied strict scrutiny. I've done um, a video regarding standards of review when there's a suspect class, when it has to do with classifications, fundamental rights. So standard strict scrutiny says that, well, if a suspect classification, in this case, this is race, and they use the most exacting measure, the most stringent measure standard to check, and that was strict scrutiny. So it failed to meet strict scrutiny, right? And because they also went further, they said that, well, because marriage, the rights that were being deprived based on race was a fundamental right. That means, the right to marry is a fundamental right. And so they said the due process law was also violated. The due process law was violated because it's a fundamental right. And the only reason why, race was used to violate, to deprive, the Lovings, the Americans of their fundamental rights in this instance through the anti-miscegenation laws was to be able to establish white supremacy, since it was only the whites, right? It was only with respect to the other races marrying whites that the laws prohibited. So it was saying that white supremacy was a violation of the equal protection, you know, clause of the 14th Amendment. I want to stop this video here, and I've been trying to keep them under 30 minutes, and I'll continue. I'll do a part two and elaborate. But in any event, uh, the courts found Loving versus Virginia, found for Loving, and they found that the anti-miscegenation laws in the South, in Virginia and the rest of the South, were unconstitutional. And I'll talk more specifically about the arguments. My name is Oluro Timiosha, and I will keep you posted. Thank you.